The thing that's important to know about Connecticut's equitable distribution view on how we divide property is that all properties the court can look at all property regardless of who owns it and when they got it. Doesn't mean they're going to divide it equally. Doesn't mean that they're going to divide it all, but it has the authority to look at it. The court also has the authority to divide it equitably. Doesn't mean 50-50. It means fairly in light of the circumstances of that particular couple. The other thing I like to mention when I'm talking about property division is I like to make sure that I talk about prenups, because prenups in some ways create an exception to how Connecticut divides property. So we know that we do equitable distribution in Connecticut, and we know that what that means isn't equally. It means that we divide things equitably or fairly. Might be 50-50, might be 60-40, depends on the unique circumstances of that couple. So if you have a prenuptial agreement and it's valid, it follows all the rules for prenuptial agreements in Connecticut, and it's not what we call unconscionable. In other words, that enforcing the prenuptial agreement wouldn't be unconscionable. It wouldn't result in this in an outcome that offends the consciousness of the court. Assuming that that's not what's going on, you can pre-decide how assets will get divided should you divorce in advance. So we do equitable division in Connecticut, but if you have a valid prenup that isn't unconscionable, the court will follow that agreement when dividing assets.